Hello and welcome to this Gowling WLG webinar on the Pension Regulator's new DC Code and Guide. By the end of the session, we hope you'll know what these materials cover, why they have been put in place, and take away some ideas and practical action points. Today's presentation will last for just over 30 minutes. There will be time for your questions at the end, and you can either stay online with us for another 10 minutes or catch up with the transcript later on. Before we get started, there are just some housekeeping points. The webinar player has a few simple controls. The most important are the volume control and full screen option, which are at the bottom right-hand side of the player. There are also some tabs along the top which you click on to access details of today's presenters, the slides, and links to materials such as our recent alerts and the codes and guides on the Pension Regulator's website. You can ask us questions at any time, and we do encourage you to do that. Click on the Ask a Question tab, type in your question, click Submit, and we will try to answer as many as we can in the time available. There is also a poll tab, as we've thrown in a few polls to encourage participation. You don't have to participate, but during the webinar the poll will automatically flash up on your screen, and we'd really welcome audience views. If for any reason you can't see the current slide, just click on the Slide tab to get back to it. Today we have Ian Chapman-Curry and Joanne Tibbett presenting. They are both lawyers in the pensions team here at Gowling WLG, with years of experience between them in advising schemes of all shapes and sizes, and they're familiar with all aspects of the pensions world. I would just mention that as this is a webinar, there's no need to point out the location of the ladies' and the gentlemen's facilities, but we're not aware of any fire alarm testing. So if the bells do sound, your speakers will be scurrying towards the fire exit with all due alacrity. And on that note, it's over to Ian and Jo to take you through the nitty-gritty of the new DC Code and Guide.
Thanks, Mags, and thanks for joining us today on what promises, at least in London, to be potentially the last day of summer. So we do appreciate you taking some time indoors rather than enjoying that. So as Mags says, we're going to be covering the DC Code, the new DC Code that was issued in final form in July of this year. But let's go back right to the fundamentals. Why do we have defined contribution schemes at all? And the regulator has quite specific views on this. It's for members to achieve an adequate income in retirement. And in case you're in any doubt whatsoever, the regulator goes on to state that this is the ultimate outcome. So it really does go to the heart of everything that a DC scheme should be offering. So where does all the focus on DC governance come from? Well, this hasn't just come out of the blue from Brighton, from nowhere. This has been a long time in development. This is something that has come out through papers, consultations, workshops. It's involved the Pensions Regulator, the Department for Work and Pensions, the Office of Fair Trading, all kinds of stakeholders, and many people on this call will have been involved with that as well. So those papers started off with the Pension Regulator setting out 6 principles, 6 guiding things that it thought were really crucial in terms of DC governance, principles to adopt in the design, setup and the ongoing operation of DC schemes. And then, if anyone who's read about these can forget, there were 31 quality features. So 31 things that the Pension Regulator thought that you should do. And the Pension Regulator, though, is really ahead of its time. It's almost a BuzzFeed article. 31 things that your pension scheme needs to have. Check them all out here. But ultimately, by the time we get to 2013, November 2013, in final form, we get 6 principles plus 31 quality features coming together in beautiful harmony into just one code of practice. Code of practice number 13 on the governance and administration of occupational defined contribution trust-based pension schemes, by saying that after you've had a drink. And that's the code that we've come to know and love, at least for the last 3 years. So why now in 2016 are we revisiting this? Why is the Pensions Regulator once again focused on defined contribution? And there's a number of reasons. Things basically in the intervening 3 years have moved on. One of the key facts is that workplace pension reform automatic enrolment has now been in place for over 4 years and has been a success. There are literally millions more people saving into workplace pensions, the vast majority of whom are saving into defined contribution schemes, both a combination of contract-based personal pensions, but interestingly, a huge number of occupational pension schemes, or the multi-employer master trust, the Nest of this world are all examples of that. So these arrangements are literally having millions more people. Also, the law has changed. The government recognised that with so many more people saving in workplace pensions and defined contribution arrangements, they had to put in place, or they had to at least think about, charge controls, the things that members were required to pay. And that's especially important if you have people who are being enrolled into default. So they might just be going in through inertia. They're not making decisions. They are being automatically enrolled into things, and it's even more important that there is a good governance framework in place, and things like charge controls, which include things like the cap on member contributions. It covers the ban on active member discounts, and it includes the ban on member-borne commission payments. All of this then comes together in terms of the concept of value for money, and it's something that we are going to come back to. It might be referred to as value for members or value for money, and it's a concept that really does act as a thread through the whole of the DC Code and guides, and really does go to the heart of both the legislative backdrop to this, the policy intention, and what the Pensions Regulator is saying is important in relation to this. And then just to bring all of that together, why is the Pensions Regulator trying to put this in as accessible a form as possible? Because it has a statutory obligation, its principles to promote trustee knowledge and understanding. It wants to get this message across and to enable people to understand why DC governance is so important. And with that, we're brought right up to date to 2016. I'm just going to hand over to Jo, who's just going to finally look at the new code and guide.
Thanks, Ian. So the new code and guide, as many of you as trustees or people who advise trustees, in April 2015, huge new raft of legislation, obligations, duties came into force, which trustees had to comply with. The regulator finally caught up now and issued its new guide, new code of practice and supporting guide, which were in force from July this year. So Code of Practice 13 has been updated. The code covers 6 key areas. So just to run through those very quickly. So the trustee board, how do you go about appointing your chair? Specific obligations which apply to master trust, for example. Scheme management skills, how should your trustee board be run? Administration, investment governance, and I'm going to come on to talk a bit about security of assets, which is certainly a thing that's exercising a lot of my trustee clients at the moment. Value for members, a very important part of the new governance framework, and communicating and reporting. And we'll come and look in a bit more detail shortly at the new guide, which cover each of those 6 key areas. And what the code does is set out standards that the regulator is expecting trustees of schemes with money purchase benefits to adhere to. And just moving on to, well, what is this actually, what's the new code actually covering? We're all used to referring to the code of practice as the DC code, and we still do that. But in actual fact, it goes wider than that. So we're not just looking at pure DC schemes, we're looking at schemes that provide money purchase benefits. And Ian's going to come on to, in a couple of slides' time, to actually explain the types of schemes that might be caught by the new code. Because I know we've had clients within the team who thought, oh, actually, these don't apply to us. But actually, when you dig a bit deeper, there's certain historical benefits hidden there to which the new requirements actually do apply. So that's an important point which Ian's going to cover. So what do you actually need to know? Well, as I've mentioned, the code's in force. for a lot of trustees who've been trying to get up to speed with the new duties, it's really important to be familiar with the codes and guides, and a lot of trustees are having them on agendas for trustee meetings that are now taking place after the summer break. Focusing on money purchase benefits, 6 key areas, and it sets out the standards that the regulator does expect of trustees. The code is quite short. It's supported by practical guidance, which sets out what the regulator regards as best practice. And also, it provides example checklists and templates, which are very useful for trustees in working out what they might be communicating to members, etc., or how they're going to approach communications. So as I've said, we have a new code for a new world, lots more obligations on trustees. Just to recap, the regulator has intended with the code that it's going to be much shorter, user-friendly, setting out the legal duties and standards of conduct and practice, with the 6 guides supporting the code, practical guidance and recommending best practice and examples for trustees. I think they're really helpful documents. They're very easy to read, and I'd highly recommend that if you haven't already done so, have a look through them. If there's any particular areas, value for members that you're grappling with, then the regulator side really is a good starting point. So, as you can see on the next slide, we've come on quite a long journey, as Ian has said. The regulator has taken a bit of catching up in terms of whether when the duties came in and issuing its code. But I think what's important to bear in mind is, well, why do we actually care about what the code says? It's not a statement of the law, and there's no actual direct penalty for failing to comply with it. But what it's intended to do is help trustees discharge their legal duties. If you don't comply with your legal duties, penalties can be imposed under the Pensions Act 95 and other legislation. So I think it's really important for trustees to bear in mind what the regulator is saying in meetings when they're deciding how to approach value for members and other aspects that are covered in the code and guide.
Okay, thanks for that, Jo. So we've got the new code in place. What exactly does the code cover, and more importantly, what do the guides cover? So the DC code is split into 6 sections, and there are 6 guides that go with each of those 6 sections. So it's well thought through in the sense of having those things all split up, and you can read the section in the DC code and then go to the relevant guide which will correspond to that section. So guide number 1 is covering the trustee board, that looking at the composition of trustees, skills, how you might appoint trustees, and it's also looking at the chair of trustees, a very important role that the pension regulator and legislation place a lot of emphasis on. Number 2 is looking at scheme management skills, and that's everything from being able to understand contracts and the procedures that are in place on delegation and being able to monitor what's actually happening on the scheme in terms of working with providers and being on top of all of that sort of thing. Number 3 is focused on administration, and that's really at the heart of what the regulator wants to get across. Good administration is one of the key components of ensuring good member outcomes, and if we go back to the first point that I made, the pension regulator is focused on good member outcomes, because ultimately that is why we have DC schemes, to ensure that members have money that they can retire on. And that leads nicely on to number 4, which is investment governance, because members will have money to retire on, not only from contributions, but also on money that is returned as a result of investments. So there's a lot of attention on investments, and Jo's going to be covering security of assets as one of the key concepts in a lot more detail. Something that can result in members having less money in retirement is if they're paying a high level of charges or other things. So number 5 is focused on value for members, or value for money, ensuring that members get good outcomes because the trustees have thought about whether costs in the scheme represent good value for members. And finally, on communicating and reporting, how do you communicate with your members? How do you convey important information? And this is really important, and the regulator is one of the things that the regulator has statutory obligations to do to promote understanding of pensions, but how do you communicate, especially with younger workers in their 20s and 30s, that decisions they make now will have material consequences 30, 40, 50 years in the future. It's a really tough ask, and the regulator is appropriately enough asking people to have a think about that. So that's what in the code and the guides. Who is the code going to actually apply to? So the code applies to occupational trust-based pension schemes. It doesn't apply in the personal pension or contract-based world. That has a separate regulatory regime that's overseen by the FCA. It applies if there are two or more members, and that's members whether they're active, deferred or pensioner. And the most important thing is, as Joe pointed out in terms of the name change for the code, it applies to schemes that offer money purchase benefits. So that includes AVCs within otherwise defined benefit schemes. So in some ways, the forgotten elements of defined contribution, schemes where the bulk of governance time, trustee meeting time has been focused on defined benefits because of much bigger headline things, deficits, being able to afford to cover promises and things like that. But AVCs and the DC pot, the regulator would argue, also deserve more attention. So that means a much broader range of schemes are going to be subject to the new code than you might at first glance think. Everyone understands that if you have a pure DC scheme that's an occupational trust-based arrangement, that the code is going to apply. It's obviously also going to apply if you have DC sections within schemes that offer mixed benefits, or a hybrid scheme as you might know it. But it also, crucially, is the money purchase AVCs within occupational DB schemes, and also money purchase benefits that have a DB underpin. So you get all these kind of complexities. And as Joe pointed out, there's also those hidden historical benefits. We have a few schemes in the team where, because there are historic DC benefits in the scheme, more aspects of the DC code and the legislative regime underpinning it apply than the trustees at first thought, and it's prompting them to take action as a result. So one of the things that the code really focuses on is best practice. It sets out what the legal obligations are, but it also sets out in a lot of detail what the regulator thinks are examples of best practice, and what the regulator expects trustees to do. So I've just thought about a few that really just raised my eyebrows when I was reading through it. Things like having a data review that has to be carried out at least annually, or having a procedure manual that has quality assurance details, continuity processes and procedures. Now, the pensions regulator will be at pains to say that trustees need to consider whether that represents value for money and to do things that are appropriate for the type of scheme, but it's the trustees that have to make that decision. And it's an important point that the one size will not fit all. The regulator is not saying this is appropriate for all schemes in all circumstances. Instead, it's putting the onus very much on trustees and their advisors to think about carefully what the membership needs in those particular circumstances. So going on just to some more elements of this best practice, things around having sensible, low-cost things like including the pension regulator's Scorpion leaflet if you're sending out annual statements, being aware of scams and pension liberation, and things around the annual report, so making sure that you include information about policies in relation to long-term sustainability, the stewardship of DC assets, and I know that's an issue that people have already raised with us before the webinar. So it's an issue that is interesting people, and also non-financial factors. So things that are very current are being covered. So as well as the best practice, the pensions regulator has also set out a whole range of checklists and examples. And if there's one thing that might encourage you to read the guides and the code, it's that the regulator has provided a whole range of really quite useful things. It might save you time, it might save you money, because it has these checklists and examples, which can be a real helpful thing if you're going through any of the processes that are shown on screen. So things like the contract review checklist, it's just a really handy headline way of making sure that you've thought about all of the things that you might need to think about. Obviously, I'll also be at pains to say it doesn't replace having appropriate legal advice, but it's certainly all the help you can get in those things is worthwhile. So that's our overview of the DC code and some of the elements of it, and we're just going to spend the rest of the webinar focusing on some of the main issues that have arisen in practice. And obviously we're only a couple of months into the regime, so we don't have a huge amount. And one of the first ones is around the appointment of new trustee members. And when I was going through the code and guides and setting out all of the steps, it's actually quite an exhaustive list of things, and it's also again something that the pension regulator is at pains to point out, that it will depend on the complexity and the size of the scheme. So all of these things will not necessarily be appropriate for smaller schemes. But having said that, there are elements that again raised eyebrows. So first of all is considering that everyone who is a trustee is fit and proper, not only at the time of appointment but throughout their trusteeship, so that they continue to be fit and proper. And that ties into some of the concepts that are going through on the defined benefit side. So things around the concept of what is a 21st century trustee, what does trusteeship look like in an age when you have far more professional trustees, or where you have a post-BHS British Steel world, where there's a lot more media scrutiny on the role of trustees. So the regulator says if you have an identified gap, if someone has resigned or stopped being a trustee, one of the things you should do is do a bit of skill mapping and see what type of vacancy there is. What skills did the person that's leaving take with them, and what do you need to try and replace? And that's an interesting one in terms of skill mapping, because I've certainly advised on a number of schemes where they just didn't have the luxury of choice in terms of people who were willing to take the trustee role. So the idea that you could actually select based on skills, there'd be some schemes saying the chance would be a fine thing. But just say that you do get to that stage. The regulator also notes that you are required to conduct references and do background checks, and sets out things like checking on Companies House, checking Companies House for records of directorship, for bankruptcies, doing conflict of interest checks, and also getting references and even doing criminal record checks. The regulator points out that you can rely on what the employer says. And then there's interview and testing. The regulator suggests that you might even want to do psychometric testing, and then having an induction and training period, and then going through all of this when you come back to succession planning. So we're now just going to go over to the first poll.
Okay, and what we're asking here is, which of these techniques have you used as part of the appointment of a new trustee? And you can tick as many of these as you like, or as few even: interviews, training, induction, skill mapping, and psychometric testing. But the question should be coming out to you now, and we'd be interested in your views.
Thanks, Mag. So hopefully that is appearing on your screen. Are we starting to get responses in?
We've got a few in, but I would encourage you to participate.
Yeah.
Just a few. Keep going, guys. Press a few buttons. Aha, thanks very much. Now you're answering. That's fantastic. Okay, we're doing well. We've got loads of replies now. Thank you for that.
People were just being a bit shy.
I think so. Okay, well, can you see the results on your screen there?
Coming through?
Yeah, fantastic. Okay, well, an awful lot of you are using interviews and training as you'd expect, and induction, but there's not so much psychometric testing going on, which I think is quite interesting, Ian.
Yeah, it's not something that I thought many schemes would be doing.
No, and it's not something we've seen at all for schemes to have the facilities and budget, frankly, to run those kind of exercises. It's a tall order, I think. And quite often, while psychometric testing can sometimes be useful in identifying where a candidate's weaknesses might be, my own personal view is that having someone in the room, having an interview with people who know what they're looking for is a sensible way forward.
Yeah, especially because you'll be working with those people.
Exactly, yeah. Okay, so I'm just going to talk through briefly the role of the chair in the DC world. Most schemes that I work with already have a chair of trustees appointed, but what I wanted to explain was that there's now a legal requirement for all money purchase schemes to appoint a chair. And what the regulator is looking for is someone who will run the trustee board in a similar way the chair of a corporate board would run that board. Chairs have one additional role, so the production of an annual statement, and I'll come on to that shortly. But in terms of what the regulator expects of a chair, well, they expect them to be an effective leader, as perhaps you might guess, so someone who can have an independent viewpoint, recognise trustees' qualities, and have a strategic view, so to have that overview of where the scheme's going and where it might need to be taken in terms of investment governance, for example. And someone who can really run the scheme to high standards with a view to getting the best outcomes for members. In my experience, these days, a lot of chairs are often professional trustees, and Ian's already mentioned the regulator's 21st century trustee governance paper. And I think one of the things they're looking at is whether there should be any standards of entry for professional trustees. A lot of the trustees we already work with are already operating to a very high standard, but how do you measure them against each other, and should there be a global standard for that? So in terms of the skills that the regulator expects the trustees to have, well, it's a difficult role to fill, but if it's your day job, if you're a professional trustee, then you'd expect professional trustees to have a lot of these skills already. And I've just listed those on that slide. And I think certainly in a lot of the trustee meetings I go to, a lot of trustees are already demonstrating those qualities. But again, it's identifying and making sure that you're having sufficient training, that you're challenging other trustees, you're challenging your advisors. And those are all important skills, I think, in making sure you have a chair who's running a scheme effectively. And now the additional obligation I mentioned, the chair's annual statement. A lot of you, I expect with DC schemes, will already have been grappling with this already. So it's a yearly statement included with the scheme's annual report and account. And I think it's important to bear in mind that it's disclosable to members. I was asked a trustee meeting where I was asked the question of, well, who is the chair's statement actually for? And whilst it's obviously demonstrating that trustees have complied with their legal duties, I think it's really important to consider what information you're actually putting in that statement, which could be useful to members. And certainly some schemes are considering, as well as having the report in the statement in the annual report and account, providing a summary version in very plain English, which can go to members to demonstrate the process that the trustees have gone through in terms of looking at value for members, the charges, etc. And I think that could be really useful for the membership. In terms of when the statement's issued, so for the first annual statement, for a scheme year ending on or after 5th of July last year, that would be when the first statement had to be provided, unless the scheme year was after the 5th of April and before the 6th of July 2015, in which case it could be rolled over. And what I mean by that is that shorter period could be included in the statement for the following scheme year. So I'm going to hand over to Ian now, who's going to talk to you a bit about value for members and what the regulator expects.
Yeah, and this is something that we could do an entire webinar on its own, and it's a good point to say this is an overview webinar. If there are subjects that you would like us to cover in more detail, then please drop us a line, because we would love to talk to you about those things. Value for members doesn't mean low cost. That's something that the regulator is very keen to get across. Also, value for members is going to be different for different schemes. What the regulator would like trustees to do is look at their own membership, look at the demographics, the preferences and requirements of members before deciding what value means. And it also is encouraging you to look at this in a more in a holistic sense and looking at the broader elements of good value. Looking at things over the longer term rather than focusing on a snapshot or just in the short term, and thinking about the things that members get the benefit of that they might not necessarily pay for. So if things are paid for by the employer, or if the cost of certain things are paid for by in a large part by the amount of money that an employer contributes, it might be that the members are getting a decent value for money in that sense. We're just going to have our next poll now, Max.
Okay, and this time we're asking, have you discussed the issue of the security of DC assets at a trustee meeting or with your provider or advisors? And you've got one option here, guys. It's either yes, in detail, or yes, it's been raised, not yet, but it's on the agenda, or no. So if you could press your buttons, that would be fantastic.
Thank you very much. I always feel like that I always feel at the cutting edge of technology with these things, which just shows how behind the times pension lawyers can be, because these have been around for a long time. Are we getting people coming through now, Meg?
Yeah, they're coming in, but a few more answers would be just fantastic to give us a really good view.
And just to note, just aware that we have hit 1:30. We're going to have about another 5 minutes. Joe's going to be just speaking on a very interesting issue of security of DC assets, but we are aware that we said half an hour, so if you do need to ring off, we will be providing the recording and the full transcript, and we'll also have time for your questions after Joe's done a bit on security of assets.
Okay, we've got some good results here coming in now.
Okay.
Can you see that?
Yeah. So
a really good response there, guys.
Really interesting that basically it is something that is on the trustee agenda. The overwhelming majority of schemes, this is something that's being considered. So it is certainly something that is being raised and discussed.
Yeah. So I'm conscious of the time, and I'm conscious that a lot of you have already said that this is something that you've already raised and are looking at. So I just wanted to give you a sort of a summary of the issues and what we think trustees need to be doing if they haven't already done it. So when we're talking about security of assets, we're really talking about, well, how safe are members' DC pots while they're invested? And the types of questions that leads to is, well, what happens if a provider fails? Can members get their money? Is there any compensation? And this isn't a new area. There was already a requirement in the investment regs to ensure that when you're making investment decisions, they're made in a manner which ensures, amongst other things, the security of the portfolio. But I think in the increased age of auto-enrolment and also closure of DB schemes, and also the regulator has focused on this in its code and guidance, it's something that trustees are having to engage with. So in terms of compensation, well, isn't that covered by the Financial Services Compensation Scheme? And a lot of trustees, perhaps before the regulators updated code, thought that actually if it's not DB, it probably is covered. But the reality is that generally pension funds can't claim from the FSCS. And whilst there may be a possibility that trustees can claim if they have long-term direct insurance contracts, it's a really complex area that's been untested, and whether or not you might be eligible for compensation will very much depend on the arrangement you have with your investment provider. So is it a direct contract with the provider? Do you have any kind of platform in place? And if so, what's the structure of that platform? What's the recourse to the underlying funds, for example? And that brings me on to what I've identified as 3 key risk areas in terms of security of DC assets, which I've listed on the slide. So provider or manager default, do you know what would happen in that situation? What's the legal structure of the product you have in place? Cross-contamination, a lot of big life companies have several business lines. So if something happens to the business, could the life business asset be called upon by another part of the business? So the annuity business, for example. And finally, as I've previously alluded to, what happens in the case of third-party default? You know, could your platform provider actually access those underlying funds? And if it could, how will it recover from them, and up to what amount? And those are all areas that I think trustees need to bear in mind. Particularly, I put an extract from the Code of Practice. I'm not proposing to read it out, but the regulator really is expecting trustees dig deeper and ask questions and find out and try and establish what protections they have in place, and also communicate the outcome to members, which in itself is not going to be an easy thing to do. So just a few things which might be helpful for the trustees. The Guide to Investment Governance, that provides details of what the regulator expects. And within that document, the regulator refers trustees to the Security of Assets Working Group Guide. Whilst that document isn't intended to provide answers to trustees, it certainly does help them formulate the right questions to ask of their providers, so they can go to their investment provider and say, please tell me what protections I have in place, how the platform works, how I can access, how you might be able to access the underlying funds on my behalf. And that's the stage, the due diligence stage, that's important for the trustees. And then once you have responses to those, is there any risk that the scheme's exposed to? And is that risk acceptable? Do the trustees need to ask any more questions? And finally, the regulator says, well, actually, you might want to consider, it would be best practice to communicate the conclusion of your review and any actions you've taken to members, which of course is not going to be a particularly easy thing to do. And just as a final point, sort of in terms of actions for trustees, I think one of the things I would say is that this is not something you need to panic about, but I think it's about taking a measured and proportionate approach. So keep a watching brief, ask the right questions, ask your advisors to help you formulate the right questions and review those responses for you. That's something that shouldn't just happen when you're appointing a new investment provider, so going through a tender process. Have you looked at your existing arrangements? When did you last look at them? Do you know what the contractual arrangements say? What are the protections? Who's the contract actually with? And those are all of the kind of things that would be helpful for the trustees to do in demonstrating that they have discharged the duties that the regulator expects of them. Member communications, that's a really hard one. I haven't actually seen any communications yet on security of assets. I'm sure a lot of you are working on them with your advisors, but I think it's going to be very difficult to balance the needs between providing information in terms of what protections are in place and also setting hairs running. And finally, security of assets, it's not the only piece of the investment governance jigsaw. It's one part, and having an overall framework in place that looks at security, what your default fund looks like, what your charges are all very important aspects that trustees should be focusing on in the new world of the new DC code. And then finally, I was just going to mention, what do good member communications look like? This can vary enormously between schemes in terms of the technology you use to push communications out to members. Is it letters? Is it email? Is it apps on phones, for example? But I think whatever method you're using, I think the second column there really demonstrates the importance of having clear messages that are relevant to your members. And, pensions is tricky. Plain English is always going to be really important in trying to increase member engagement. And I think we're now on to our final poll, Mag. So
yeah, that's right, Jo. The last poll today is, do you use technology as part of your member communications? And again, you've got a choice of 4 answers. No, not at all. A bit, but we are still mainly paper-based. A lot, online, email or by text. And finally, yes, most of our communications are digital. So if you could give us your answers to those, that would be helpful.
Perfect. And whilst we are waiting for some responses, we'll make good use of the time and answer some of your questions. The first one that we've had in, and we've had some great questions. Some of them are very interesting, and so interesting that we're going to take them offline and give them the attention they deserve. So if we don't cover one that you've asked, we will make sure that we follow up and get you some responses. But the first one is a chair's statement required where you only have ABC benefits in a DB scheme?
And the answer to that is no. It's very clear in the regulator's guide that you don't have to produce a chair's statement if you just have ABCs. But again, it's been really careful to make sure that the ABCs are actually ABCs and not something else. Because we've had a couple of clients that thought that was the case and have been caught out and have been subject to the requirement.
To the whole thing, and that's the point.
Exactly.
It's an interesting quirk that where you might have historic DC benefits in, and the code will then not just apply in terms of those money purchase benefits, but potentially the whole lot of any money purchase benefit. So it is a difficult one there. Another question was, do you think that new trustees should complete all modules of the trustee toolkit that the pension regulator offers within the first 6 months? So the pension regulator says that trustees should have a period of training to get up to scratch within 6 months. And what do you see with clients using it? Get mixed views on that. It's important to note that it's not fundamentally a requirement, and also to look at the skills and training requirements of the individual. So if you have someone who was PMI qualified and trained, then teaching them how to suck eggs by doing the whole of the trustee toolkit might not be relevant. And it is a fairly decent time commitment. It does take time to go through it. That said, it's useful. It sets out scenarios that you might not have thought about if you haven't taken a trustee role before. And also you get your confirmation that you've completed it at the end, which might be helpful if you need to demonstrate what you've been doing for TKU.
I mean, I think the only thing I'd add to that is that I've got trustee clients that say, yes, you should complete the toolkit within the first 6 months, but I've got some who provide their own training program, in which case there may be duplication there, and people got busy day jobs. So it's just working out what works best for your scheme in the context of what you're providing, but I do think it is a useful tool.
Yeah, exactly. Okay, Max, what results did we get for the last one?
Well, more than 50% of you are using technology a little, but they're mainly still paper-based, Ian.
Yeah, no, that doesn't surprise me. And again, it just goes back to looking at your membership, what's appropriate, and also the value for money point, because there's no point buying a very expensive suite of digital communications that can't represent value for money just for the sake of having digital communications. People have been writing letters for centuries for good reason, because it's a very good way of conveying information. That said, there are ways of doing things cheaply, and over time, the ubiquity of digital communications means that's going to become more common. Just before we ring off, I just want to highlight a couple of future events that might be of interest. We are one of the panel speakers at the DC Insight conference on the 26th of October. You can find out more about that in the resources tab. There's a link through to that. You can register. There's also our All About Age evening event on the 4th of October, which again, details of that are in the resources tab. And that's all from us, Mag.
Okay, so it just remains for me to say thanks for joining us for this webinar on the DC Code and Guide. Just before you go, there's a very short feedback questionnaire, and we'd really appreciate it if you could take a moment just to fill this in. This helps us to ensure we cover the issues that you're really interested in. And if today's webinar sparked your interest, then you can find more resources on the Download tab, including a version of the slides that you've already seen today and various alerts and links. And if you'd like to go over anything from today's webinar or would like to share it with colleagues, the recording and a transcript will be available shortly, and we'll let you know when these are ready. So finally, thanks to Ian and to Joe and to you guys for making the time to join us today. Thank you.
Thank you very much.
Thanks very much.